Okay, Shannon put us on the record.
Okay.
Okay, this is a matter of Force versus Sanava. Counsel, state your appearances, please.
Good afternoon, Your Honor.
Good afternoon, Your Honor.
On behalf of the defendant.
Okay, I didn't hear
Let's
anything.
let's start with the plaintiff's counsel.
Good afternoon, Your Honor. John Marco on behalf of the plaintiff Patrice Force.
Your Honor, Michael Franz on behalf of the defendant.
Can you spell that, please?
F-R-A-N-Z.
Thank you.
Okay, and this is defendant's motion. I'm gonna adjust my camera just a little, so so plaintiff's counsel gets as good a look at you as you've got at him. How's that?
Thank you, Judge.
This thing is really touchy. All right. Now we'll zoom in.
Do you mind if I use the lectern, Your Honor?
If you want to, you're welcome
I'd just
to.
rather stand if it's okay.
Yeah, that's fine. But now I gotta change my camera.
Yeah, that's why I was letting you know so he can see me there.
All right, that looks pretty good. All
Thank you,
right.
Your Honor.
I have read your briefs, but you may go ahead with your whatever additional argument you think I need to hear.
Thank you, Your Honor. I will try to keep this brief, although brevity, unfortunately, is not one of my better qualities. I want to just start backwards in the briefing and point out something I think is extremely important here, because frankly, Judge, I think we all know if there's a question of fact, and there's no summary disposition in this case, if there's a question of fact. The plaintiff has submitted in the response brief a plethora of medical records, purportedly, because they're not attested to by anyone, and one affidavit. It's the affidavit of Dr. Shiner. And in my reply brief, I raised the issue, Dr. Shiner's never been disclosed as an expert witness. And I attached as Exhibit 6 to defendant's briefs the plaintiff's only answers to interrogatories disclosures in this case. And on the very end of the disclosures, plaintiff was asked the interrogatory, please identify each person you expect to call as an expert witness at trial. And plaintiff's response was, plaintiff will file a witness list in accordance with the court's scheduling order. All treating physicians will testify as experts. That's just a mistake in spelling, experts in their respective fields. That's already pointed out in the reply, but what I'd like to highlight here is if you turn back to page 2 of the answers to interrogatories and plaintiff's answer to number 5, where the interrogatory asked plaintiff to name the treating physicians. Plaintiff did name treating physicians, none of which was Dr. Shiner. So even if plaintiff could make the argument that the disclosure in the answer to interrogatory number 31 somehow disclosed treating physicians as experts, which I would debate that, but even if that disclosure in answer 31 did disclose the treating physicians to the defendants as people that may be called as experts at trial, or at least made defendants aware of that, if you simply refer back to the answers to interrogatory 5, it lists a Dr. Double, a Dr. Kumar, a Dr. Tawanda Crawford Johnson, then it lists the Henry Ford Health Center, Dr. Zedba, and Jeff Frohmeyer, who's a rehab person.
What's the date of Dr. Shiner's affidavit?
Well, I don't know that, but his examination of the plaintiff as attested to in his affidavit April 30th, 2019. The date of his affidavit, as far as I know, I don't think it was dated, but it was attached to the response to the motion for summary judgment, plaintiff's response. And that's the first time it was presented to defense counsel. So I think the Michigan rule.
So if she wasn't there to be treated, or he, I can't remember, do we have
The plaintiff is a she.
if she wasn't there to be treated, why was she seeing Dr. Shiner?
I think plaintiff's counsel is better to answer that question. I can only suppose for an expert evaluation. Nonetheless, Dr. Shiner was never disclosed in this case. And just to remind Your Honor, this is the case, I was in front of you in January.
I remember the case.
This is a case that has a corresponding federal court case. And at the time, Your Honor had said, can you guys find a way, essentially, to just get these cases consolidated together into the federal court case? And I looked into the procedure on it, Your Honor, and I don't know of any procedure that allows me, or even you, to order the state court matter to consolidate it into the federal court case. I would if I could. Nonetheless, though, seeing that Dr. Shiner's affidavit is the only sworn testimony presented by plaintiff that in any way provides medical testimony as to the plaintiff's physical condition, that's the only evidence presented by plaintiff that we're here on today, that Your Honor can consider. And that affidavit should be stricken, and Your Honor should not consider it, because Dr. Shiner, simply put, was never disclosed as a witness. He wasn't a treating physician, he wasn't disclosed as an expert, and the first time he emerges in this case is in plaintiff's response to defendant's motion for summary disposition. So taking that into consideration, Your Honor.
Well, so I'm troubled by what you say, that the only thing in the response that identifies injuries or damages is this affidavit. I'm looking at the plaintiff's response. We've got a Dr. Kumar diagnosed post-concussive features, black eyes, memory loss, suspected brain injury.
Those are reports, Your Honor. Those are medical reports. There's no attestation.
I hear you.
And what you just said actually does not even address the no-fault threshold issue. Those are contemporaneous reports of the plaintiff's injuries at the time of the accident.
And those have no bearing on the threshold?
Well, first of all, they're not attested to. So Your Honor could not consider them. You just can't consider essentially inadmissible medical records.
The summary disposition rule requires that you respond with counter affidavits, deposition, testimony, or records. So here are records. Can't I reasonably assume that these doctors are going to testify consistent with their records?
If you go through those records, Your Honor, and I would dispute that. I believe the Michigan rules require sworn testimony, whether by affidavit, deposition, or in another form. And I believe, Your Honor, that's from, I cited the case of West versus General Motors, which is a Michigan Supreme Court case in 2003, which says an opposing party may not rest upon mere allegations or denials of pleadings, but must by affidavit or sworn testimony set forth specific facts showing that there is a
Bless
genuine
you.
Thank you.
issue of material fact.
Okay, hold on a minute. So I'm looking at the court rule. The initial burden is on the moving party. To supply affidavits, depositions, admissions, or other documentary evidence in support of the grounds asserted in the motion. And then, under subpart 4 of 2116G, G. When a motion under sub-rule C10 is made and supported as provided in this rule, an adverse party may not rest upon the mere allegations or denials of his or her pleadings, but must, by affidavits or as otherwise provided in this rule, set forth specific facts showing there's a genuine issue for trial. And then under subpart 5, the affidavits, together with the pleadings, depositions, admissions, and documentary evidence then filed in the action, must be considered by the court when the motion is based on grounds that include C10. This says I have to consider the documentary evidence. I can't ignore it as you're asking me to. I have to consider it.
Well, Your Honor, there is a specific case which is cited in defendant's reply brief. It's Van Every versus Southeast Michigan Transportation Authority. And that case provides that testimony of a medical provider concerning diagnosis that is contained in medical records is inadmissible for purposes of a motion for summary disposition. And in order for the plaintiff,
Give me that case again.
Van Every,
Give me a second. I'm going to
Sure.
pull it up. Take me a moment to get the browser open. What's the site?
369 Northwest 2nd, 875, and the specific page is 880.
Van Every, okay. Let me get to that page. And I'm sorry, tell me the 811 or
880.
880, hold on. Oops, went too far. There we go. This deals with the admissibility of a particular record into evidence at trial. This has nothing to do with whether or not the document could be considered for purposes of responding to a dispositive motion. I don't see how this provides any guidance when I got a court rule that says I have to consider the document.
Well, what it says is that medical records concerning diagnosis are inadmissible. So if it's inadmissible at trial, it's certainly inadmissible on consideration of a motion for summary disposition.
Well, what this case was talking about were notes in the medical records that were made by someone other than the diagnosing physician. Here, I'm assuming the diagnosing physician is going to speak to his own diagnosis in the medical record that he prepared.
Well, even if that's correct, Your Honor, even if that's correct, I mean, and that's an assumption we don't have before us, at least on the briefs. But even if that's correct, if Your Honor did look through all the medical records provided in the response, there's no diagnosis or opinion in those records by one of the treating physicians in the records, which speaks towards the plaintiff's injuries meeting the threshold requirement of the No-Fault Act. None of those records do. The only thing proffered by the plaintiff that addresses whether or not the plaintiff sustained a permanent injury as required to file a third-party tort lawsuit beyond the No-Fault Act is Dr. Shinier's affidavit. In that affidavit, he opines that he believes she has brain damage, brain injuries. That's not contained in any of the medical records that are made as an exhibit to the response.
I get that whatever diagnosis that Dr. Shinier made isn't in the medical records.
No, what I'm saying is if you look through all those medical records that are attached to the response, they don't have any opinion stated in there which addresses the exceeding the threshold that she has a permanent injury. Those treating physicians did not address if she had a permanent injury in their opinions in the unverified medical records. Reaching that hump, Your Honor thus can only consider the three affidavits that are provided in the motion for summary judgment. And those are, the first two affidavits are doctors that were retained to provide IMEs in the no-fault case. And it's worth pointing out, these doctors were never disclosed by the plaintiff to the defendant. These doctors, and you'll see in their affidavits, both attest under oath that she does not have permanent injuries, and the plaintiff has reached maximum medical improvement. And those examinations were not too far after the accident, March 20th, 2019. The accident happened on July 9th, 2018. So March 20th is Dr. Fabiano. March 29th is Dr. O'Connor. Those were hidden from the defendants. And I say hidden, and I mean hidden, because they weren't disclosed here, and Mr. Marco was the plaintiff's attorney in the no-fault case. I had nothing to do with the no-fault case. I found out about those IMEs because I looked into the no-fault case doing my background research on this case. And I found that these two people had examined the plaintiff, and those were their findings. And it's very circumstantial, if not clear, that the reason those were not disclosed to the defendant is because those opinions effectively would defeat plaintiff's claim under the No-Fault Act. And simply put, plaintiff doesn't reach that bar of a permanent injury to file this third-party lawsuit. Now, in a lot of situations, granting of summary disposition would mean the plaintiff would have no recovery. I'm not gonna stand here and tell you the plaintiff wasn't injured. I'm not gonna say that at all. She was injured I believe she was injured as a result of the automobile accident. I think she fully recovered from those injuries, and she was compensated for those injuries under the Michigan No Fault Act. The Michigan legislature decided to do that long ago. And they allowed an exception to be able to file a third-party lawsuit, but they put in some very specific requirements. And the plaintiff here simply does not sustain that burden to exceed the threshold requirements of the No Fault Act. Finally, Judge, there was Dr. Fletcher, who is defendant's retained expert witness, and Dr. Fletcher examined the plaintiff on April 27th, and he specifically says under oath the plaintiff did not sustain a traumatic brain injury, neurological, or a permanent physical injury. And I think everyone is very well versed in the requirements of the Michigan No Fault Act, and if you can't show that, then you cannot sustain the burden of such a claim. And as such, the plaintiff's, the defendant should be granted summary disposition. Thank you, Your Honor.
Thank you. I don't need to hear a counter argument. I think the documents do create a question of fact. I'm not ruling on whether or not Dr. Shiner's affidavit itself is admissible, or whether, irrespective of Dr. Shiner's affidavit, the other records are sufficient to create a question of fact. If you expect to use Dr. Shiner and you didn't previously disclose him, you're going to have to justify why you didn't do that, but I'm not going to address that today. You would have to make a motion to amend your witness list to include him. I give you no indication one way or the other whether I'd be receptive to that, but I can't really address that today, and today I don't need to, because I think the other documented medical records are sufficient to create an issue of fact. So,
Thank you, Judge.
if you would,
Do you want to?
if you would submit an order under the 7-day rule denying the motion for the reasons stated on the record.
I'll have that submitted this afternoon, Your Honor. Thank you very much for your time, and thank you. I'm sorry I couldn't be there in person, Judge.
That's all right. I prefer that you come by Zoom, but you can come to the courtroom if you want. I think it's just safer for everybody if you don't. But
Could we discuss possibly just scheduling?
sure.
Well, I don't think we need to set anything in stone, but so the federal case has a oral argument on a motion for summary judgment on August 31st. And
You're not going to get a trial here before August 31st.
I certainly, I recognize that. I don't expect, in fact, any courts to impanel any civil juries in 2020.
We are doing this week a mock jury trial, or mock jury selection at least, at an event center that I hope to be able to attend to see how it goes. But that'll perhaps give me some sense as to whether or not we're going to be able to. The plan is to do jury selection there and then come back to the courthouse to do the trial. That way, at least we avoid assembling a large group of jurors in a very compact jury room. So we can at least avoid all of the risks, or many of the risks inherent in jury selection.
Excuse me.
Then it still remains a question to me whether or not we could still safely do a jury trial in a civil case here in my courtroom. I mean, the jurors would have to wear masks the entire time. My jury deliberation room is pretty compact. So those are open questions, but I'm at least hoping to get a little better sense so I can figure out whether I can even start scheduling jury trials. What I've told my civil secretary is don't bother rescheduling any for now, just to unschedule them. Let's keep a list as they come and go, and we're still not ready to do the trials. We just put you on the list and take them in order. But I think it could be a few months before that's realistic.
I would just make two suggestions, Your Honor. One, that we set a future case management conference, and by Zoom is fine by me. The other is, this is for the plaintiff to consider. Defendants would be willing to move forward on a bench trial by submissions to the court with testimony and with sworn testimony. Plaintiff probably won't agree to that.
I can't imagine a plaintiff's lawyer ever agreeing.
Neither can I, but I wanted to throw it out there.
In a personal injury case, but.
I want to throw it out there because I've heard that proposed in other people who really want to get towards a judgment. That's been thrown out there. So,
has there been any settlement discussion?
We had a facilitation on Monday.
We had a mediation with Dan McCarskey. Defendants had relayed that they felt extremely confident about their motion, and I felt extremely confident about our response. So we were waiting till you made a ruling today to see what happened, and then we're going to revisit that. I think there might be a mediator's number that will be put on the case. If that doesn't settle it, then I would ask for to be put on the list, I guess, so to speak, that you're referring to with the first available safe civil jury trial. Certainly, we don't want jurors worried about their.
Yeah, you don't have a current trial date?
It was today, Your Honor.
It was, oh,
okay.
okay.
Stricken that a few weeks ago.
Okay, yeah, you are on the list. And as soon as I can start doing trials, I'm going to do them. I will probably schedule multiple trials on the same date. And as a practitioner, I hated that when judges did that. But I don't have any choice. If we're gonna get the docket moving again, I'm gonna have to do that. I can't afford to let a jury trial date pass with no case waiting to be tried. It's just, I hate to do it to you guys. I hated it when it was done to me, to have to be ready for a trial and all the preparation that goes into that, only to find out, sorry, we'll get back with you in a couple of months. I don't like that, but I don't see any way around it. That's what you're going to be saddled with, gentlemen. It's the only way we're going to get the docket moving again, when we're finally able to get it moving again.
Does Your Honor engage in cases you're presiding over in pretrial settlement conference?
I have.
Defendant would be open to that.
I would suggest you, now that if the major obstacle was the ruling on this motion, that you at least revisit facilitation and see what happens. If that's not successful, I'm willing to put in the effort to try to help you to settle the case.
Thank you, Judge.
So anyway.
Would Your Honor like a status date?
I don't really need one at this point.
Okay.
When either one of you wants one, get a hold of Patty, say, we'd like a status conference, and we'll get you on the calendar. I don't, until we have a better handle on what's going on, I don't even know how realistic a status conference is. Maybe after you've gotten a ruling on the federal case, that might help. I don't know.
Well, Judge, today was extremely helpful. And I think there's going to be res judicata issues. So there might even not need to be a ruling in the federal case now. And I think we'll work together to move this as quickly as we can. And with the crazy world that we live in now. So as soon as there's.
All right, well, gentlemen, as it occurs, I've got a settlement conference ongoing right now, and I got to get back to them and see if they're making any headway. So
thank you, Your Honor.
thank you,
All right,
gentlemen. Have a good day. Be safe.
Hey, Judge, have a great day.
Thank you. You too.